Please be seated. The sitting is open. The court meets this afternoon to hear the second round of oral argument of Venezuela on the merits in the case concerning arbitral award of the 3rd October 1899, Guyana versus Venezuela. I note the presence of Her Excellency, Ms. Delcy Rodriguez, Acting President of the Bolivarian Republic of Venezuela, in the Great Hall of Justice. I now invite Professor Paolo Parchetti to address the court. You have the floor.
Mr. President, members of the court, last Wednesday, Venezuela demonstrated what the real issue in these proceedings is. Not the validity or invalidity of the 1899 arbitral award, but the pursuit of a mutually satisfactory solution by Guyana and Venezuela. Venezuela addressed in detail the interpretation and legal effects of the Geneva Agreement, as well as the historical circumstances that led to its conclusion. Venezuela had hoped that during the second round of oral pleadings, Guyana would finally engage with Venezuela's argument concerning the Geneva Agreement. Guyana has not done so. On Friday, Guyana has again largely ignored the Geneva Agreement. What we have is a fragmented response on few selected points. This is unfortunate, as Friday was Guyana's last opportunity to finally reply to Venezuela's extensive arguments on the Geneva Agreement. Unfortunate, but not surprising. From the start, Guyana has sought to divert attention from the only legal instrument that defines the rights and obligations of Guyana and Venezuela by focusing exclusively on the 1899 arbitral award. As you heard on Wednesday from Venezuela's agent, Professor Moncada, Venezuela is here to respond to Guyana's erroneous and misleading narrative. As in the first round of oral hearings, in this second round, Venezuela's main focus will be on the interpretation and the effects of the Geneva Agreement. Albeit irrelevant, the issue of the award's invalidity will nevertheless be addressed in order to respond to Guyana's unfounded allegations. Today, I will begin Venezuela's second round of oral pleadings by addressing the issue of the invalidity of the 1897 arbitration treaty and that of the invalidity of the 1899 award for lack of reasons. I will be followed by Professor Christian Tams, who will rebut Guyana's argument on excess of power. Professor Jean-Marc Touvenin will then address the alleged waiver by conduct of Venezuela's right to raise the nullity of the arbitral award. This will bring us to the Geneva Agreement. Professor Andreas Zimmermann will rebut the few arguments made by Guyana on its interpretation. Next, Professor Makam Beng will address novation, decolonization, and the importance of identifying the real issue before you. Her Excellency, Ms. Ariadne Seijo Nogueira, will give an overview of the arguments advanced by Venezuela before the court. The second round of Venezuela's oral pleadings will close with the intervention of the acting president of the Bolivarian Republic of Venezuela, Her Excellency, Ms. Delcy Rodriguez Gomez. Mr. President, I will now address the invalidity of the 1899 award. On absence of reasons as a self-standing ground of invalidity, I will make one point only. On Friday, Guyana insisted that the court's judgment in the King of Spain case is irrelevant for establishing whether at the end of the 19th century, arbitral tribunals already had an obligation to state reasons in their awards. Let me explain why Guyana is wrong on this. Nicaragua had asked the court to determine the invalidity of the award rendered by the King of Spain for lack or inadequacy of reasons. The court addressed the merits of this contention, and in assessing it, the court did not dismiss Nicaragua's claim on the ground that in 1906, arbitral tribunals had no obligation to state reasons. Rather, for the court, the award was valid because, and I quote, it deals in logical order and in some detail with all relevant considerations, and it contains ample reasoning and explanations in support of the conclusions arrived at by the arbitrators, end of quote. Of this very standard, the award of 1891 falls short. Significantly, both Honduras and Nicaragua admitted the existence at the relevant time of an obligation to state the reasons in the award. This is Professor Rollin on behalf of Nicaragua. I quote,
It was only at the end of the 19th century that the practice was firmly based on the need to provide reasons in awards.
Tribunal between Great Britain and Venezuela was rendered at the end of the 19th century, at a time when, as remarked by Professor Rollin, the general practice confirmed the existence of an obligation to state the reason. The tribunal did not comply with this obligation, and for this reason, the award is null and void. I move now on to the invalidity of the arbitration treaty. Mr. President, members of the court, Venezuela and Guyana hold opposing views regarding the role played by Venezuela in the negotiation of the arbitration treaty. Guyana pretends that Venezuela was closely involved in the treaty's negotiation. This, according to Guyana, is fully documented and uncontested. The fact that Venezuela played no role in the negotiation is, Guyana adds, simply part of Venezuelan current mythology, the product of the imagination of counsel who would say n'importe quoi just to be allowed to the podium. In short, Guyana attributes to Venezuela the very practice of distortion of facts that permeates Guyana's narrative. Venezuela rejects this baseless accusation. Venezuela's historical position is based on a great amount of concordant contemporaneous evidence. This evidence is the result of careful and in-depth research conducted by historians, beginning with a seminal work carried out in the 60s by the Venezuelan experts Herman González Oropeza and Pablo Ojer Serigueta. The products of this historical research have been confirmed by non-Venezuelan historians who have worked on the Venezuelan crisis. For instance, this is the position of a great British historian, Robert Arthur Humphreys. I quote, "The United States, with British concurrence, acted on Venezuela's behalf, but Venezuela herself was not consulted, or rather, she was not consulted until the very end of the negotiations, and then only perfunctorily. Venezuela, said only on one occasion, has got to do exactly what we tell her. He only revealed not the slightest wish that she should be represented by one of her own citizens on the Tribunal of Arbitration, which he proposed should be set up. And when a final agreement was reached in Washington, her president, Crespo, was simply given to understand that it was very just and fair, and that he had better expedite its completion, or it would be bad for his country." End of quote. Humphrey's position cannot be dismissed as biased. He was the professor of Latin American Studies in the United Kingdom. This passage comes from a speech delivered at the Royal Historical Society in 1967, when Humphreys served as its president. His position coincides with that presented by the Venezuelan experts contemporaneously. Humphrey's factual account is the same that you find in Venezuela's written pleading and that you have heard on Wednesday. The fraudulent attitude. Venezuela's President Crespo was simply given to understand that the agreement was very just and fair. The coercion. Venezuela has got to do exactly what we tell her, and President Crespo had better expedite its completion, or it would be bad for his country. The historian's work confirms that the injustices suffered by Venezuela were not a fabricated myth, as Guyana would have you believe, but a fact. Nevertheless, the 1897 treaty was not simply unjust, it was invalid. The text of the agreement submitted to Venezuela was not the text agreed upon by Great Britain and the United States. Venezuela was not informed of the confidential notes exchanged between Olney and Poncefort. On the confidential notes last Friday, Guyana has made 3 points. First, Venezuela is hiding their text from the court. Second, Venezuela's 2 representatives in Washington, Storro and Andrade, were privy to the confidential notes. Third, if Harrison, the US lead counsel for Venezuela, was not aware of the existence of these notes, it is Venezuela's fault. On the first point, Mr. President, there is nothing to hide. The document has long been part of a documentary record of the present case. For the sake of clarity, you can find it again at tab 58A of the judge's folders. It is clear from this note that Olney and Poncefort had agreed that the critical date for calculating the prescription period was the date of the conclusion of the arbitration treaty and could not be 1814, as first argued by Venezuela, based on a reasonable interpretation of the treaty. On the second point, there is nothing in the documents presented by Guyana that proves that the Venezuelan minister in Washington, Andrade, had been informed of this confidential note, except the fact that one day Olney received Andrade and Storro at his home. This proves nothing. It would be hard to understand why Olney expressly characterized this document as strictly personal, if in the end all parties concerned were informed about its content. But there is more. Let me come back to the letter I presented to you last Wednesday, the letter of Olney to Poncefort, dated 24 May 1899. As you will recall, this letter is a reply to a letter in which Poncefort informed Olney of Great Britain's intention to present the confidential note to the arbitral tribunal. In his reply, Olney, after emphasizing that the negotiation was conducted, I quote, mostly by informal personal talks or, so far as the negotiations were in writing, by equally informal and private notes, end of quote, asks Poncefort, and I quote, do you not think that it would be unfair that one out of many notes so exchanged should be selected for publication while the remainder are suppressed, end of quote. Mr. President, where would be the unfairness if all the parties, the United States, Great Britain and Venezuela, were aware of the content of these confidential notes, as Guyana claims? Unfair to whom? Certainly not to Great Britain or to the United States. They knew about the existence of these documents. If it is a question of unfairness, the reason is clear. Venezuela was never informed of the existence, let alone of the content, of these confidential notes. Concerning Mr. Storo, I think that I do not have much to add to what I already said on Wednesday and what you find in Venezuela's written pleadings. Storo is central to Guyana's strategy. Let's take a look at footnote 14 in Guyana's second round of oral pleadings. Everything revolves around the correspondence between Storo and Olney. Without Storo, Guyana's attempt to prove Venezuela's participation to the negotiation collapses. There is no evidence that Venezuela was involved in the negotiation, because it was not. In fact, the correspondence between Olney and Storo confirms that Venezuela was absent from the negotiation. Reading this correspondence carefully, one can see that there is not a single reference to the position of the Venezuelan government. One would expect to find sentences like, "I have instructions from Caracas," or "I need to consult the Venezuelan government." Nothing of the sort can be found in the correspondence. Olney and his close associate, Storo, exchange views and impressions as if Venezuela did not exist. Finally, let me come to Harrison and his lack of knowledge of the existence of the confidential documents. Guyana's argument is always the same. If Storo knew of the notes, Venezuela knew too. If Harrison did not know of the notes, it is Venezuela's fault. Guyana wants you to believe that whatever Storo or Harrison said or did, this reflected the position of the Venezuelan government. This is baseless. Last Wednesday, Venezuela presented multiple pieces of evidence showing that neither Storo nor Harrison was loyal to Venezuela. On Friday, Guyana offered us half-hearted defense of Storo. It didn't even try to defend Harrison. In fact, the evidence shows, most simply, that Venezuela was never informed of the confidential notes. But if further proof were needed, let us look again at the letter that Olney sent to Ponsefort on 24 May 1899. Olney candidly recognized that Venezuela could not have been aware of this confidential correspondence because he himself had expressly denied its existence. I quote, "Further, entre nous entirely, being inquired of last summer on behalf of Venezuela respecting diplomatic correspondence preceding the treaty, I replied that my letter to you of 13 July 1896 was the last thing of record. The Council for Venezuela would be both surprised and irritated, and perhaps justly so, if now confronted with a writing they had been led to believe did not exist." End of quote. Mr. President, Venezuela has been victim of fraud, and the evidence before you amply justifies the conclusion that the arbitration treaty is invalid, and as a consequence, the award is invalid. The evidence before you, as well as the work of the historians, both Venezuelan and non-Venezuelan, also show the injustices suffered by Venezuela. It is not a myth, it is a fact. I thank the court for its kind attention and ask Mr. President to give the floor to Professor Tams.
I thank Professor Pachetti for his statement. I now give the floor to Professor Christian Tams. Sir, you have the floor.
Mr. President, members of the court, it's an honor to address you with brief comments on the invalidity of the 1899 arbitral award. Mr. President, on this award, Guyana has tried to build its case. At the start, it placed us on a pedestal. On 3rd October 1899, it said at the opening, and I quote, "International law spoke." It spoke, Guyana said further, through the voice, and I quote, "of eminent jurists whose fairness and integrity were widely recognized," and making 3rd of October, and I quote again, "a special day for the rule of law internationally," end of quote. We have come a long way. As these hearings end, the award appears in a very different light. Guyana no longer makes a positive case. It has become defensive, relying on intertemporality, formalism, and acquiescence. A reasoning was not yet required, it says. Pushing through a deal, that's fine, it says. Venezuela accepted it, after all. Never mind the fact that it faced civil war and military threats. And of course, challenging this award, you have heard, would open floodgates. Mr. President, from highest honors to barely enough to pass. Now, of course, Venezuela does not accept that this award passes any test. But we believe that Guyana's new approach reflects clarifications that these proceedings have brought about, and I will highlight 3 of them. I begin briefly with the question of titles to territory. These titles under Article 3, the tribunal had to investigate and ascertain separately from any boundary determination, and it failed to do so. Guyana on Friday argued that the tribunal had decided on titles by implication when it drew its boundary line. But this construction, a decision by implication, undermines Article 3 and the parties' position. The parties addressed titles as an autonomous matter. And as one example, you see on the slide excerpts from Venezuela's counter case. It is the final section entitled Judgment Invoked. And in this final section, Venezuela asked the tribunal to render judgment on, amongst other things, Spain's discovery of America and its legal relevance, on, and I quote, submissions on title. Mr. President, the tribunal could not fail to respond to these explicit submissions, and to do so was for it a dereliction of its duty. My second point, equally brief, the navigation regime for the rivers Amacuru and Parima. The parties agree now that the tribunal had no explicit mandate to impose such a navigation regime. Guyana's reference to Article 4, paragraph C of the treaty ignores the clear and strict narrow wording of the provision, which is, as I suggested on Wednesday, about, and I quote, the determination of the boundary line, not about anything else. On Friday, Guyana referred you to a passage of the pleadings where Venezuela, according to Guyana, had accepted that Article 4C gave the tribunal a right to decide on aspects relating to the legal relations between the parties. But, Mr. President, this passage does not help Guyana. In it, Venezuela did not discuss navigation. The parties never did. But it discussed the impact of the eventual boundary decision on existing land grants and concessions. Land grants and concessions. This is the context for which Article 4C may have been intended. Navigation is not by any stretch, whether of imagination or of legal reasoning. By pronouncing on navigation, the tribunal showed the same cavalier approach that marked its failure to not decide on legal titles. It plainly acted ultra vires. last, Guyana accused Venezuela of having, and I quote, opened before us a world of theater and fiction, not law, not fact, end of quote. It explicitly claimed, and I still quote, that claims about Mr. Malé-Prévost's conversations are demonstrably untrue or wholly uncorroborated, end of quote. Firm words, no slip of the tongue. But what a difference a week makes. On Friday, Guyana sounded very different. The private conversations recounted by Malé-Prévost, but also by Lord Russell and Martens, to which I had taken you, were not the only ones, Guyana now seems to say. The tribunal also held regular sessions. And initially, Guyana now seems to say, the arbitrators did advance legal views. And as for President Martens' insistence on pushing through a deal, Guyana now says that the president was moved by a perfectly decent quest for unanimity. Mr. President, I will respond to these points on how the deal was struck uncorroborated. Are they, as Guyana said exactly 1 week ago in this room, demonstrably untrue? Of course not. Quite the opposite. These oral hearings have corroborated that conversations described by Mr. Malé-Prévost, confirmed by Lord Russell and President Martens, did take place. They have demonstrated that during these conversations, the tribunal determined the boundary line. This was a political deal. Guyana no longer disputes, and we welcome its change of position on this, the core issue. What about Guyana's attempts to explain away this now undisputed fact? Well, Guyana cannot ignore what happened in the 6 days of deliberations. What Guyana asserted on Friday was that the arbitrators initially formulated legal arguments. But when the decision was reached, when the deal was struck, the law was silent. But, Mr. President, members of the court, the Paris Tribunal was not tasked to try out a bit of law, and when that fails, strike a political deal. Its mandate was clear. It had to decide based on principles of international law. Yet after Guyana's pleadings on Friday, it is clear that this was a political deal. A political deal pushed through by President Martens, whose line, as Professor Touvenin will show shortly, was neither based on titles nor on occupation. A line of convenience based on a... Now, Guyana says that this deal was all part of a laudable quest for unanimity, for which President Martens cannot be faulted. The response to this can be brief. It can be brief because the mandate addresses the issue. The tribunal had to render a legal decision, and as Article 5 made clear, it had to do so, and I quote, by a majority. The quest for unanimity did not justify the deal. If anything, it shows that the tribunal operated in its own universe, a universe in which the personal predilections of a president trumped the terms of the mandate. Mr. President, discussing the tribunal's deal on Friday, Guyana referred you to former President Bejawi's writing on the manufacture or fabrication of ICJ judgments, suggesting that it could help us assess the 1899 award. And we agree. We agree that, as Guyana suggested, this manufacture will involve a give and take, though I cannot help but add that President Bejawi reflected on the give and take that was inevitably involved in the drafting of a judgment's reasons. For our purposes, another passage of President Bejawi's piece is more apposite, it seems to us. In this other passage, President Bejawi formulated a clear red line, and we suggest this is key to appreciating the 1899 award. This is what he said, and I quote, "It must never be forgotten that it is the absolute duty of a judge to reject any compromise incompatible with his innermost sense of justice and of the limits of the reasoning that may lead to it." End of quote. This absolute duty, the tribunal members ignored in reaching their deal, as these oral hearings have shown. It is as simple as that. Mr. President, members of the court, let me conclude with one final remark. It concerns the point of connection between the three excesses of power I have now discussed. These point to one inescapable conclusion. This tribunal showed no respect for the terms by which the parties had defined its task. It operated according to its own logic, deciding what was not asked of it, ignoring what it had to decide, and violating its absolute duty to decide on the basis of law. We might say, as we have in the written pleadings, that in rendering this award, this tribunal went rogue. Now, despite Guyana's strained claims to the contrary, the result of this rogue award was a disaster for Venezuela. President Martin's compromise line gave Britain over 90% of the disputed territory, and what Venezuela retained, control of the mouth of the Orinoco, was not seriously in contention, as Lord Russell had noted. During the proceedings, and I quote, "Britain had explicitly admitted that the Orinoco was Venezuelan," end of quote. Now, Punch magazine, as often, knew what to make of the award. It understood the central message that Guyana tries to obscure. The Punch cartoon of 11th October 1899 is on the slide. It is entitled "Peace and Plenty." It shows Prime Minister Lord Salisbury chuckling, as it is said in the caption, barely capable of holding on to everything that this arbitration delivered for Britain. Territory, gold mines, wrapped up nicely in the Union Jack. The caption says, "I like arbitration in the proper place." Mr. President, members of the court, this arbitration may have brought plenty for Britain, but it did not bring peace. Amidst the civil war, faced with regular threats of military invasion, from the British ultimatum of 1895 to the crushing blockade European powers imposed on it soon thereafter, Venezuela was not in a position to react meaningfully. As many other nations in colonial or quasi-colonial situations, Venezuela had to put on a brave face. It had to accept the 1899 award, which enacted coercion through the civility of the legal form. If I can return to the language of PhD exams, this award deserves neither a summa cum laude nor even a rite. It is a fail. This concludes, Mr. President, my remarks today. I thank you for your attention and would ask you to please call to the podium Professor Jean-Marc Touvenin.
I thank Professor Tams. J'invite maintenant le professeur
I would now like to invite Professor Jean-Marc Touvenin to address the court. You have the floor, sir. Thank you, Mr. President. Mr. President, members of the court, before I start talking of the theme that I have been asked to dwell on, I would just like to make two series of observations. First of all, pertaining to the maps and the lines, let us look at the map that Mr. Reichler authoritatively showed you on Friday to justify, as everyone will recall, that the Spanish occupation between the Orinoco and Essequibo rivers up to 1799 had existed only in the western half of the area, and that, I quote, "none of the settlements were in the territory awarded to Great Britain." End of quote. In short, the award would have assigned to Venezuela the entire part that the Spanish missions had historically occupied. But on closer inspection, we can see that in the southeastern part of the area, very close to the Essequibo River, there is a Spanish fortification called Castillo el Burgo. And a little further north, on the top right side, on the coast immediately west of the mouth of the Essequibo River, between Ciudadelo de Pomoron and the Ciudadelos de Morocco, lies the Misión de Santa Rosa de Morocco. This is a Capuchin mission of exactly the same nature as those in the western part of the area, which Guyana has apparently recognized as being under Spanish occupation, and they lie squarely within the territory ceded to the British Crown by the 1899 arbitration. But let's look at some other maps now. This is how the Spanish viewed the border with Dutch Guyana in 1778 at the Morocco River, slightly west of the Essequibo. And here is how the British viewed the border with Dutch Guyana in 1806 on the Essequibo. Now, here's the same view from London in 1822. Here is how the British on the ground viewed the boundary. More specifically, Hatfield, who was the official cartographer of the British Empire, and he was specifically tasked by the governor of the British colony of Guyana with marking its boundaries on a map. This is the official Hatfield map of 1838. We can see the western boundary of the British colony on the Pomoron River, very close to the Morocco River. We can also see inland the note, the Cuyuni and a considerable portion of the Masrouni are yet unexplored. In short, whilst you were assured on Friday that, I quote, evidence shows continuous occupation of the territory by the Dutch and then the British, unquote, the British themselves on the ground were saying exactly the opposite. But London had other ambitions and had commissioned Schomburg to draw a line that was purely imaginary. This is the official line of the British claim from 1840, as explained by Sir Edward Hertzlet in the memorandum of September 1886 that I quoted on Wednesday, and which you will find in your files under tab 61. How can such a discrepancy with the line on the Hatfield map be legally justified? It simply cannot. In 1844, clearly giving no credence to the Schomburg line, which had been strongly rejected Nassau at the mouth of the Morocco. Whilst the starting point on the coast makes sense, and as we recall, had convinced the American arbitrators, it is difficult to see why it extends into territories which the British themselves acknowledged that they had not even explored. There is obviously no legal justification for this. Sorry. My apologies, Mr. President. I'm unable to get the right page out. Here we go. Schomburg died in 1865, yet a new Schomburg line suddenly appeared in 1875, and that is the yellow line that you can see here. Is there a legal basis? None. The West. Why? Because that's what took the empire's fancy. This is 1886 now. Here is the Rosebery line in pink, simplifying the 1875 Schomburg line with straight lines. And it is just as fanciful as the previous ones, it nevertheless retreats slightly eastwards compared to the Granville line. Sacrilege? But in 1887, here is a new Schomburg line in red. Schomburg had been dead for 22 years, but miraculously, his new line largely follows the Granville line of 1881, which, rather annoyingly, found no support in the Schomburg Line of 1875, unfortunately adopted by Rosebery. Then came a second Rosebery Line from 1893 in black. He had finally learnt the game of lines. And this was followed by the extreme British claim of 1896, which is another red herring, as an Englishman might say. The 1899 ruling largely follows the 1887 Schomburg Line, which largely corresponds to the 1881 Granville Line, but with a small section of the 1886 Rosebery Line added to the north. Perhaps so as not to offend any of the lords. It is a patchwork, or rather a compromise or a deal between not different British and Venezuelan claims, but between the various British claims of 1881, 1886, and 1887. What, may I ask, is the legal basis in international law? None. I now turn to a second series of observations concerning Iribarren Borghes's declaration. It was made about a month after the signing of the Geneva Agreement. And it is the wrong key that was used by Guyana throughout this procedure. I pointed out last Wednesday that this was a political, erroneous, and legally untenable declaration. And rather than calling me Pinocchio, which may have been thought in pepto in private, I was told that I was cheeky to make such an enormous and outstanding statement. Serrano would reply to his detractor, "Oh no, young blade, that was a trifle short. You might have said at least 100 things like this by varying the tone like this, suppose." The word lawyer does not appear in Serrano's speech, but it is indeed a lawyer's tone that must be adopted to assess in legal terms the statement made by Iribarren Borghese. Is this an interpretative statement? Certainly not. And this has never been claimed. Is it a reservation? Probably not. Is it then an act falling within the scope of customary law as codified in Articles 31 and 32 of the Vienna Convention on the Law of Treaties? Not that either. So what legal effect could it possibly have on the interpretation of the Geneva Agreement? None. It is an internal declaration for domestic policy purposes made after the treaty entered into force. Is it a reliable declaration? Iribarren Borghese says the following of Article 7, and I quote, "With regard to Article 7, it is clear that when the law approving the agreement is submitted to this sovereign Congress, the agreement will enter into force upon ratification of said law." End of quotation. That is also wrong. Article 7 stipulates that the agreement had entered into force upon its signature. According to the terms of Article 4, in the event that no satisfactory solution for Venezuela is reached, the so-called 1899 award shall be revised through arbitration or judicial recourse. End of quotation. Therefore, assuming that the work of the Mixed Commission failed to produce a satisfactory solution for Venezuela, the award would have to be revised through arbitration or judicial recourse, that is to say, rewritten de novo from scratch. If the text were not rewritten, according to Iribarren Borghese, there would be no question of challenging the validity of the award judicially. Mr. President, Guyana cannot just cherry-pick from the Iribarren Borghese Declaration whatever suits it, that is to say, the utterly incomprehensible interpretation of Article 5 of the agreement from which it's drawn its conclusions, whilst ignoring or distorting what it finds inconvenient. Venezuela, for its part, adheres to the Geneva Agreement and nothing but the Geneva Agreement. I'd now like to come to my main topic. What about Venezuela's alleged waiver of its right to rely on the nullity of the award? The argument is both unacceptable and unfounded. Venezuela asserts and maintains that there is no room for this Guyanese argument in the context of the application of the Geneva Agreement. During what I have termed the Geneva process, the United Kingdom's position regarding the controversy at the heart of the Geneva Agreement never concerned Venezuela's conduct following the 1899 award. The sole point of disagreement between the parties was whether or not there was evidence of the nullity of the award as such. The court noted this in 2020, in fact, observing that the discussions between the parties regarding the nullity of the 1899 award had focused solely on, I quote, the documentation relating to it with a view to assessing the merits of the Venezuelan position regarding its nullity, end of quote. And that this examination, I quote again, was undertaken by the government of the United Kingdom, end of quote, and that it was, I quote, on this basis that the subsequent meetings held in Geneva in February 1966 took place, following which the agreement was adopted, end of quote. Throughout this process, the British did not produce the maps published by Venezuela since 1905, nor did they produce the press cuttings unearthed last week by a Guyana busy rehashing its submissions. And during the meetings of the mixed commission established by the Geneva Agreement, Guyana did not say a word, not a single word about Venezuela's conduct after 1899, confining itself, in its own words, to inviting Venezuela, and I quote, to produce evidence and arguments in support of her basic contention that the 1899 arbitral award was null and void, end of quote. It was not until 1981 that Guyana put forward this argument. It was at this point that Guyana began to blow cold or backpedal. It has no right to do so on the grounds of estoppel. And I explained this last Wednesday. Guyana's response was none.
However, let us nonetheless look at the argument based on Venezuela's inaction. In his lecture given at the Academy on Prescription in International Law, Roger Pinto posited that the inaction of the holder of a right is only enforceable against them when it is unjustified. This is the ratio discendendi that lies at the heart of the case of the award of King of Spain. Nicaragua offered no justification for its delay in asserting the so-called nullity of the award. This raises two questions. Firstly, is it unjustified not to claim the nullity of an arbitral award when one fears reprisals? If one does so, certainly not. Our opponents do not seem to dispute the principle, but rather dispute the coercion in this case and challenge Venezuela. Where is the contemporaneous evidence? Challenge accepted. Anyone can see the documentary evidence on which Venezuela relies, for example, by carefully rereading the pleading by my colleague, Professor Azaria, as well as Venezuela's rejoinder. Moreover, one need only refer to the report by Venezuela's Minister of Foreign Affairs, Rafael Sejas, dated the 4th of May, 1900, used selectively by Guyana, but so that's fair enough. And here are a few relevant extracts regarding the impossibility of repudiating the award as early as 1900. I quote, "It is not to be assumed that disavowal of the award by Venezuela would be successful. The shift in the political stance of the US does not permit the hope that the rejection of the judgment will find favor in Washington, still less when one considers that the two American arbitrators concurred in it. We must not rely on this protection in this case." As regards Great Britain, its contempt for the weak being notorious, and its persistence in laying hands on the mouth of our great river, a plan on which it has been working since the end of the 18th century, it is considered not only that it would not agree to Venezuela's opinion that the case should be reopened, but that it would take advantage of it with a view to retaining what it still holds and very probably extending its encroachment. It would require very substantial reasons for this, and their reference is made to the challenge of the award. Whatever our opponents who are at odds with history may say, Venezuela was faced with a gross injustice, which it did not welcome at all, and without the means of denouncing it, without substantial reasons, namely without evidence, facing a lasting situation of coercion, which was not merely structural, but very real, as Venezuela found out shortly after the Paris decision, when its protests against European imperialism were brutally suppressed during the 1902 blockade. Second question. Is inaction on grounds of a lack of evidence justified? This has always been Venezuela's position. In the note of the 22nd of February 1962, in which Venezuela formally claimed that the 1899 award was null and void, the representative of Venezuela stated clearly that, and I quote, "the strange circumstances in which the Paris decision had been arrived at began to unfold from the very day of the decision. But it was not until several decades later that the truth of what had occurred could be confirmed." End of quote. A few days earlier on the 14th of February 1962, in a letter addressed to the Secretary General of the United Nations, Venezuela's representative had also written that, and I quote, "when it obtained clear evidence of the defects which invalidate the 1899 award, the government of Venezuela immediately reserved its rights." End of quote. Guyana adopts the strategy of burying its head in the sand, turns a deaf ear, and mixes up two very different things: having doubts based on confidential information, impressions, or journalistic analyses, which it calls awareness, and having evidence. Venezuela claims that it had no evidence until the publication of the Mali-Prevost Memorandum. Guyana's refusal to listen on this point is all the more incomprehensible, given that the Geneva process was initiated exclusively around the issue of evidence derived from documentary material concerning the 1899 award, an issue that only arose following the first piece of evidence, the Mali-Prevost Memorandum. And the 2020 judgment echoes that. Let us return to the evidence. It will be recalled that on Monday afternoons on this podium, the integrity of Mali-Prevost as well as that of Schönrich were called into question. The exercise, however, was both gratuitous and futile because on Friday, Guyana, in fact, went so far as to acknowledge that the facts which were described by Mali-Prevost, who was a direct witness, and which are described in his memorandum, are reasonably established. At last, it took Guyana 64 years to acknowledge the probative value of the Mali-Prevost Memorandum. It was indeed evidence, the evidence that Venezuela had been lacking in order to challenge the award. From there, as I said, Venezuela searched in the archives, which had just been made accessible, particularly those of the Foreign Office, and in the American archives to the extent that it was able to gain access to them. And indeed, that took time. Who could possibly claim that in 1950 that did not require some time to update the archives? Guyana wrongly accuses Venezuela of having kept a guilty silence between 1949 and 1962. Wrongly, while seeking additional evidence after the reading of the Mali-Prevost Memorandum, Venezuela was immediately keen to preserve its rights. And in March 1951, Venezuela's representative stated during the fourth consultation meeting of the Ministers of Foreign Affairs of the American continent, I quote, "In the opinion of the government of Venezuela, no change of status which may occur in British Guyana as a consequence of the international situation, of any measures which may be adopted in the future, or of the advance of the territory's inhabitants towards self-determination, will prevent Venezuela, in view of the special circumstances prevailing when the frontier line with the British Guyana was defined, from pressing its the Venezuelan representative solemnly reiterated that there was no question of Venezuela waiving its right. And in 1962, the Geneva process began at the invitation of the British. Mr. President, members of the court, without evidence, inaction cannot be invoked. Otherwise, the mechanism for reviewing judgments would be pointless. And in fact, we can establish a comparison. The revision mechanism would not have any point. Venezuela took action when the facts were reasonably established. From that point on, the chronology of the challenge to the 1899 award shows that it asserted its rights in due course. Mr. President, before closing, may I say a few words about the 1905 agreement, to which Guyana attaches great importance. And we move straight away to paragraph 54. The 1905 agreement is solely an agreement interpreting on the ground the 1899 award, that is to say, in plain English, a demarcation agreement. Guyana relies on the award in the Desert Lagoon case to assert that this is an agreement which was separate from the arbitral award and that it would survive the nullity of the latter. It is indeed separate, no one doubts that, but it cannot survive the nullity of the award because it merely interprets it. If the latter is set aside as invalid, the agreement interpreting it loses its very purpose. And since the circumstance which formed the essential basis of the agreement was the 1899 arbitral award, the nullity of the latter, without any doubt, constitutes a fundamental change in circumstances that inevitably brings the demarcation agreement to an end. Mr. President, members of the court, having exhausted, if not your patience, the time allotted to me, I would like to conclude by thanking you for your attention whilst requesting that you call Professor Zimmerman to the podium.
Je remercie le professeur Thévenin
I thank Professor Thévenin.
Andres Zimmerman to the podium. So
Mr. President, members of the court, I will now address the arguments finally made by Counsel for Guyana concerning the Geneva Agreement, few as they were, but limiting myself to legal considerations. At the outset, I note the many arguments Counsel for Guyana deliberately chose not to address in that regard, and I believe that this was not a mere coincidence, but rather an implicit acknowledgement that they had nothing to say on them. This included the drafting history of the Geneva Agreement, the argument based on the very title of the agreement, the Geneva Agreement's preamble, the argument based on Article 2, Paragraph 3 of the Geneva Agreement, the arguments based on Article 4, Paragraph 1 and 2 Geneva Agreement, the argument based on the subsequent practice of the parties, my arguments based on both the Port of Spain Protocol, which once again was not even mentioned, and the practice arising thereunder, and finally 8, the argument based on the understanding by the UN Secretary General of the Geneva Agreement. And that then leaves me with addressing Articles 1 and 5 of the Geneva Agreement. Once again, however, also with regard to Article 1 Geneva Agreement, certain of Venezuela's arguments were not addressed, namely that the mixed commission, given the wording of Article 1, had not been tasked to settle the controversy between Venezuela and the United Kingdom as to the validity of the award, nor that the mixed commission had been tasked to decide anything, and even less decide the issue of the validity of the award. Instead, the Mixed Commission, just like the other actors now acting under Article 4, had been tasked to seek a practical settlement of the controversy and search for satisfactory solutions to the controversy. Before moving on, it is also worth noting in passing, and indeed telling, that unlike the Washington Agreement, which had referred to a settlement tout court to be reached by an arbitration, the Geneva Agreement, in contrast, specifically aimed at a practical settlement, practical settlement, which an upheld arbitral award obviously could not constitute. Finally, Counsel for Guyana at least tried to counter my argument based on the use by the parties in Article 1 of the term controversy rather than the term dispute, and the thereby implicit reference to the overall boundary controversy that had already been addressed in the 1897 Washington Treaty. In doing so, Counsel for Guyana claimed that Article 1 of the Geneva Agreement concerns, and I quote Counsel for Guyana, quote, a controversy over Venezuela's contention that the award is null and void, end quote. That's how Counsel for Guyana described it. But as you can see, this is not what Article 1 Geneva Agreement says. Article 1 does not refer to a, quote, controversy over Venezuela's contention that the award is null and void, as Counsel for Guyana claimed. Instead, and to the contrary, it refers to a, quote, controversy that has arisen as a result of Venezuela's contention that it is null and void. Obviously, it was indeed Venezuela's contention as to the nullity that brought the underlying overall boundary controversy back to the floor, and that had therefore arisen, as Article 1 puts it. And it was accordingly that boundary controversy And that now brings me to Article 5 Geneva Agreement. I'm really grateful that we finally learned what Guyana thinks Article 5 stands for. However, Article 5 does not lead Guyana's arguments anywhere. I make several points. First, and as per its clear wording, Article 5 is intended to preserve the claims of both parties to territorial sovereignty. At the same time, however, there is no hint whatsoever in the text of Article 5 that it was meant to prevent a future practical settlement of the boundary controversy. And how could it be otherwise, since this is the very object and purpose of the agreement? In other words, Venezuela is not arguing that the Geneva Agreement had wanted to set aside any claim of territorial sovereignty by Guyana, or by Venezuela for that matter. And this again confirms that it is the overall boundary dispute and how to solve it that is the subject matter of the controversy, and thus also, as Professor Mbenge will further elaborate on, the real issue before the court. Instead, what Venezuela is arguing is that the Geneva Agreement wanted to provide how to reach a practical settlement that would address the territorial claims of both Guyana and Venezuela, and namely by way of negotiations. And this is also suggested by the very introductory line of Article 5, paragraph 1, which provides that it is meant, quote, to facilitate the greatest possible measure of cooperation and mutual understanding, end quote, between the parties. Article 5 of the Geneva Agreement therefore supports rather than precludes a practical settlement of the boundary controversy to be reached by way of negotiation as the only possible way to move forward with such practical settlement, then setting aside any legal effect the 1899 award might have, quod non. Second, I cannot but also further note that Guyana aims to assert its territorial claim through a judgment of this court, hoping that it will confirm the validity of the award. In Guyana's own reading of Article 5.2, Guyana's reading, no post-1966 acts or activities whatsoever shall constitute a basis for asserting or supporting a claim to territorial sovereignty. But how can Guyana then now assert its claim that the award is valid by unilaterally bringing in 2018 its case on the basis of the alleged compromissory clause in Article 5 of the Geneva Agreement? Thus, in Guyana's own understanding, Article 5 precludes the possibility to rely on Article 4 Geneva Agreement to have the claimed validity of the award and Guyana's ensuing territorial sovereignty recognized by the court. And this understanding of Article 5 is confirmed by the court's judgment in the Gulf of Maine case. In that case, Article 3, paragraph 2 of the compromis provided for a similar without prejudice clause as the one contained in Article 5. It was meant to keep certain claims of the parties outside of the scope of the compromis. The court's chamber found that the parties, and I quote, the parties have chosen to reserve for themselves as the subject of future direct negotiations with a view to an agreement, the determination of the course of the delimitation line between the international boundary terminus and point A, end quote. The court's chamber then reached the conclusion that the parties' quote intention to have recourse to judicial settlement must be taken within the limits in which it was conceived and expressed, end quote. Accordingly, the court's chamber then continued that in the task conferred upon it, it must, quote, conform to the terms by which the parties have defined this task, end quote. In the Geneva Agreement, Article 5 is a similar without prejudice clause. Its scope is, however, not limited to some positions or claims, as in the Gulf of Maine case, but covers all positions and claims of the parties. The only conclusion to be drawn, therefore, is that indeed, as argued by Venezuela, the parties, to use the words of the court in Gulf of Maine, quote, have chosen to reserve for themselves as the subject of direct negotiation with a view to an agreement, end quote, the solution of the controversy addressed by the Geneva Agreement. And this plainly confirms that they had no intention to have recourse to judicial settlement. Accordingly, the parties cannot have defined in the Geneva Agreement any task for the court. Third, what is more, is that Article 5 does not exclude in any manner whatsoever the search for a practical settlement of the boundary controversy by way of negotiations. The reason for this is the lack of a clause akin to Clause 3 of the Polish Danzig Agreement, which had explicitly provided that the subsequent 1923 Polish Danzig Agreement itself did not and could not set aside the legal effects of the previous decision of the High Commissioner for Danzig. On Wednesday, Counsel for Guyana tried to argue that Article 5 constitutes a similar savings clause, but maybe a closer look at the two cases would have been helpful to discern the fundamental differences between Article 5 Geneva Agreement on the one hand and Clause 3 of the Polish Danzig Agreement on the other. For one, Article 5, paragraph 2 Geneva Agreement is solely concerned with post-1966 unilateral acts of the two parties. Article 5, paragraph 1, in turn, provides that during the process of searching for an agreed, mutually acceptable practical settlement of the overall boundary dispute by the parties, any claim that the award is valid cannot be dispositive of the controversy, since this would amount to a diminution of Venezuela's claim to territorial sovereignty over the disputed territory. Had the parties indeed wanted, as Guyana wants you to believe, to foreclose any practical settlement by way of negotiations, they would have specifically said so in Article 5. But unlike Poland and Danzig in Clause 3 of their 1923 agreement, they did not formulate Article 5 in such a manner. At the same time, since Article 5 was meant not to interfere with the parties' territorial claims, its purpose was not and cannot be to safeguard the purported validity of the 1899 award by way of a judgment of the court, since this would prevent Venezuela to bring forward its own claim. On the whole, Article 5 of the Geneva Agreement therefore supports, rather than precludes, a practical settlement of the boundary controversy to be reached by way of negotiation as the only possible way to move forward. This practical settlement would set aside any legal effects the 1899 award might have, quod non, unless, following mutatis mutandis the Gulf of Maine precedent, Article 5 forecloses the recourse to judicial settlement in toto. Before I conclude, let me draw your attention to the extensive substantive discussions that took place in November 1984 between the parties. During these talks, the parties discussed in significant detail possible alternative boundary lines. While Venezuela put forward the so-called Shahabuddin line, which Guyana dismissed, Guyana alternatively proposed a potential cession of a smaller coastal strip. Accordingly, Guyana, in fulfilling then its legal obligations under the Geneva Agreement, was then willing to discuss the territorial controversy as such, regardless of its own position as to the alleged validity of the award. Although these discussions did not result in an agreement, they confirm the negotiations once more that the parties had moved on from discussions about the invalidity of the award. Why have we heard nothing, and I repeat, nothing, about these Guyanese advances and other advances made by Guyana during their oral submissions? I submit the question is best answered by Guyana's own representatives, Rochley Jackson, who in 1985 expressly acknowledged his concerns regarding public reaction say, "What is this talking about?" End quote. That statement is difficult to reconcile with Guyana's present attempt to portray the post-1966 process as involving no meaningful engagement concerning the territorial controversy itself. To the contrary, has thus played both sides of the fence. It is only during these proceedings that Guyana has adopted a markedly different and difficult to comprehend position. But Guyana cannot ex post facto undo its own subsequent practice and controversy caused by a, to say the least, as you have seen, fundamentally flawed award on the validity on which they held completely divergent views. 4 years later, with Guyana having their boundary dispute as such. And the court must not now second-guess the parties' intentions or override their free choice to opt for the path of reaching mutually acceptable solutions leading to a practical settlement of their boundary dispute. Yet, Guyana now claims that if the court were to follow Venezuela's arguments, it would lead to, quote, eternal negotiations. That warrants two remarks. For one, it is the parties' understanding of the Geneva Agreement and the parties' understanding alone by external actors. It is for that reason, I submit, that Guyana has not engaged at all ever since it brought the case before you with the practice of the parties ever since 1966 up to the 2023 joint declaration. This practice controversy by way of negotiations, whatever their fundamentally divergent views on the nullity of the award up to today are. And Guyana cannot ex post facto undo this subsequent joint practice. Finally, let us step back for a moment and reflect on the Beagle Channel conflict between Chile and Argentina. It confirms that even a conflict which, just like party, then in the Beagle Channel, may be solved by way of an agreed mediation. As you are aware, Chile and Argentina managed to reach a peaceful settlement of their long-standing controversy and concluded in 1984 a treaty of peace and friendship, which, as the parties themselves put it in the treaty, quote, constituted a compromise, end quote, solving the boundary dispute for good. Guyana has provided no answer and was unable to provide an answer anyhow. Why? What was possible for Argentina and Chile in the 1980s cannot be possible for Guyana and Venezuela today, despite Guyana's commitment to do so in the Geneva Agreement and despite the fundamental flaws inherent in the 1899 award leading to its nullity. Mr. President, members of the court, I thank you, as always, for your
Please be seated. The sitting is resumed. I now call Professor Magam to the podium. You have the floor, sir.
Mr. President, distinguished members of the court, it is again a privilege to appear before you on behalf of the Bolivarian Republic of Venezuela. You have just heard Professor Zimmerman methodically dismantling Guyana's flawed reading of the Geneva Agreement. I shall now take up the torch and address the arguments, the very few arguments Guyana managed to marshal in countering Venezuela's first round of submissions on the real issue in these proceedings, the notion of novation and the relevance of decolonization. Mr. President, Venezuela does not appear before you to litigate a case you have no jurisdiction to hear. Venezuela appears rather to ensure that its voice and the historical truth it carries is not drowned out by Guyana's monologue. Oral hearings, in that sense, are far more than the procedural right enshrined in Article 43 of the statute. They allow the international community to judge for itself the merits of each side's position. But this requires states to seize the opportunity to answer each other during an oral stage. And on Friday, that opportunity was Guyana's. It had before it 2 sets of written submissions and Venezuela's first round of oral pleadings. This opportunity, Guyana squandered. Not only did its first round of oral pleadings fail, as we demonstrated on Wednesday, to engage with the rejoinder, but its second round compounded the error, recycling what it stated in its written submissions. Guyana was there. Its team received the verbatim, and yet somehow it refused to engage. I shall nonetheless take up the few crumbs Guyana has left us and address them in turn. First, I will show that Guyana has still not answered Venezuela's position that the real issue in these proceedings is governed by the Geneva Agreement and its requirement of a mutually satisfactory practical settlement. Second, I will address Guyana's new attempts to resist the conclusion that the 1899 framework was novated by the Geneva Agreement. Third, I will return to decolonization and show why Guyana's reliance on the stability of colonial boundaries cannot displace the specific legal framework Guyana and Venezuela themselves adopted in 1966. Mr. President, delineating the real issue or subject matter on an objective basis is a fixture of international adjudication. We explained on Wednesday what is at stake, ensuring that a decision is not misled by a unilateral presentation of a case. Venezuela further demonstrated that the court is yet to identify the real issue in this case, and that this exercise leads to one conclusion. The controversy is governed by the Geneva Agreement and by the obligation it lays on Guyana and Venezuela to seek a mutually satisfactory solution. Guyana offered no answer as to the real issue. Instead, it tried to deflect the matter in two principal ways. First, Professor D'Argent quoted past statements from Venezuela's counsel to suggest that Venezuela accepts that the validity of the award is at stake in these proceedings. But it goes without saying that these statements made in incidental proceedings and taken outside their context do not represent Venezuela's constant position, and in line with both states' practice since 1966, constant position that the question of validity is moot. The same thing. There are, if you will, two circles that may overlap, and only what falls at their intersection can be adjudicated. Venezuela's position is that there is no overlap here and no role for the court to play. Guyana's sole engagement with the critical identification of the real issue was to assert that the 2020 judgment has already determined it. How? We were not told. But in the verbatim, Professor D'Argent inserted a footnote referring to paragraph 66 and 135 of the 2020 judgment. Did these paragraphs bear any resemblance to the language typically used by the court to identify the real issue or the subject matter? No. Paragraph 66 of the 2020 judgment does not even mention these terms. Paragraph 135 only makes a conclusion as to the court's jurisdiction rationnée matérielle, which, as we explained last week, differs from the subject matter. Beyond this, Guyana fell back on recycling arguments from its written submissions and thought it had found a lifeline in the doctrine of res judicata. A word is needed on this. Counsel for Guyana described again on Friday res judicata as a kind of guillotine. But your jurisprudence is clear that the court is not in the habit of fashioning straitjackets out of its own words. I shall make 3 points. First, and as put by the court in the Genocide Convention case, I quote, if a matter has not in fact been determined expressly or by necessary implication, then no force of res judicata attaches to it. End of quote. The real issue was not determined in 2020. That judgment was only on jurisdiction. It did not identify what needs to be decided on the merits. Guyana's argument would transform res judicata into something it is not, a device by which a jurisdictional judgment silently decides the merits. But more importantly, Guyana's approach conflicts with the court's jurisprudence constant, that incidental proceedings cannot ever prejudge the merits of a case. Second, the scope of the 2020 judgment's res judicata is not as broad as alleged by Guyana. Read the dispositive. Read paragraph 138. The court spoke of the, I quote, question of the definitive settlement of the land boundary. Definitive settlement of the land boundary. I emphasize the word settlement. Règlement in French. Not delimitation. Not determination of the line. Settlement. That word is precisely the language of the Geneva Agreement itself. Article 1 speaks of, I quote again, satisfactory solutions for the practical settlement of the controversy for both Guyana and Venezuela. The court followed the wording of the Geneva Agreement far more closely than counsel for Guyana. Third, Mr. President, on Friday, Mr. Reichler placed considerable weight on the reasoning behind the dispositif to sustain Guyana's view of what is res judicata. It is true that where the meaning of the dispositif requires clarification, recourse may be had to the reasoning. But the reasoning is consulted to clarify the meaning of what was decided. The meaning of what was decided, not to expand it. Paragraph 64 of the 2020 judgment, quoted in full by Guyana, records two things. One, the historical fact of the disagreement between Guyana and Venezuela over validity of the award. And two, the obligation under Article 1 of the Geneva Agreement to pursue a practical settlement of the controversy. The first, the validity of the award, is the past. The second, the obligation under Article 1, is the framework that governs the controversy today. Guyana never engages with that framework and never even properly acknowledges its existence. On Wednesday, I asked a simple question. Why was the Geneva Agreement ever concluded? What did the parties seek to achieve? Venezuela has a clear answer to that question, but Guyana offered none. We do not know what legal function Guyana attributes to the Geneva Agreement. Maybe they do not know it either. Limitations to the exercise of the judicial function which the court, as a court of justice, cannot ignore. End of quote. But if counsel for Guyana does not care for Northern Commons, perhaps they will accept Aya de la Torre. In that case, this court was asked to choose among the various ways in which an asylum could be terminated. The court declined, reasoning that, I quote, these causes are conditioned by facts and by possibilities which, to a very large extent, the parties are alone in a position to appreciate. A choice amongst them could not cause judicial function to make such a choice. 1951, Mr. President, the principal Venezuelan in the court's own words, I quote, a practical and satisfactory solution. A practical and satisfactory solution. The very language Venezuela has placed at the center of its pleadings, the very language of Article Article 1 of the Geneva Agreement and the very real issue at stake. Let me now turn on to novation. Wednesday, that his syllogism was wrong. It is precisely because of the disagreement about the validity of the 1899 award that novation became necessary. Professor Dargent argued that Article 5 of the Geneva Agreement is a saving clause that preserves Guyana's rights under the 1899 award and clauses fell. I turn first to Mr. Reichler's reading of Article 5. Professor Zimmerman has already demonstrated that the text of the provision does not support that reading, and that indeed Article 5 reflects the limits imposed on the court's decision in this case. I add only one point which bears specifically on novation. Article 5, paragraph 1 is symmetrical. It preserves bases of claim for Venezuela, for British Guyana, for the United Kingdom on the same terms to when asked what justifies its position. Article 5, paragraph 1 freezes those assertions, nothing more. So, if Article 5, paragraph 1 saves Guyana's reliance on the 1899 award, it equally saves Venezuela's contention that the award is null. Both stand. Neither is endorsed. And those two preserved assertions are, word for word, the two claims that Article 1 identifies as part of the controversy Guyana and Venezuela must settle. Therefore, if anything, Article 5 confirms novation by sending the parties' competing claims forward into Article 1 for resolution. Professor Zimmerman has already drawn the further consequence under paragraph 2 of Article 5. No post-1966 act may constitute a basis for asserting or supporting a claim to territorial sovereignty unless accepted by the parties. And a judgment endorsing the validity of the 1899 award would breach that provision. I turn now to Professor Dargent's question. What was novated? The award, the 1897 treaty, the 1905 treaty, the boundary itself? Professor Dargent said Venezuela had identified none of them. The answer, Mr. President, is the whole framework. Not any of those instruments standing alone. The framework they constituted together, a framework designed in the language of the 1897 treaty to produce a full, perfect, and final settlement of the boundary. The 1897 treaty supplied the procedure. The 1899 award supplied the line. The 1905 agreement supplied the demarcation. That framework as a whole is what was novated because it could not deliver on its promise. The Geneva Agreement replaced it with a different framework, an obligation under Article 1 to seek satisfactory solutions for the practical settlement of the controversy within the procedural architecture of Articles 2 and 4 of the Geneva Agreement. Finally, let me turn to decolonization. Mr. President, the back and forth between pleadings is helpful to shed light on a controversy. Sometimes this results in some degree of agreement. As happened here, counsel for Guyana I quote, acts of great colonial wrongdoing. And they aptly referred to the, I quote again, iconic resolution on decolonization adopted by the Geneva of the anti-colonial movement somehow became a new colonial body trying to intimidate Guyana, or of the baseless, groundless contention that Venezuela hindered or delayed Guyana's path to independence. These contentions deserve no answer. No, I'm referring to Guyana's misguided attempt to desecrate Faso, Mali for the proposition that maintaining the status quo in the context of decolonization is often, I quote, the wisest course. Professor Dargent, meanwhile, relied on this court's recent judgment, Gabon distinct that needs to be respected. These arguments are flawed. They proceed without naming it from the notion of piti possidetis, which finds no application in this case. The principle, piti possidetis, preserves boundaries that existed in law at independence or according to colonial effectivity. But we are here dealing with an external border between an already independent state, Venezuela, and a newly decolonized entity, Guyana, an entirely different situation. And an external border whose very lawfulness is the controversy. The African examples invoked by Guyana have no purchase here. Piti possidetis is the wisest course when no alternatives exist. It cannot help a state that benefits from the status quo, and it certainly cannot allow states to ignore an obligation to reach a mutually satisfactory solution. But it was Professor Sands that pushed this argument to extreme limits. He did so wielding the typical and uninspired argument that challenging one colonial border is endangering them all. This is the open the floodgate argument all over again, recycled from Professor Pelle's intervention on Monday. Professor Sands then asked whether, I quote, an age of instability and uncertainty that would run directly contrary to the wisdom of Africa is, I continue the quote, what Professor Mbeng, me, is asking you to do. Well, let me reply to this challenge directly by noting that it is once again, and regrettably, based on a failure to engage with Venezuela's case and ignore the Geneva Agreement. This is not any border that is at stake here, but a border subject to and governed by a dedicated and indeed reaching such an agreement would not destabilize international law or betray the goals of decolonization, as Guyana would have you believe. Instead, it would be international law at work, international law remedying an act of great colonial wrongdoing. And so this is the right conclusion to draw from the Geneva Agreement's roots in the decolonization movement, that the peoples of Guyana and Venezuela are the bearers of that movement's promise, and that both are best served not by a judicial endorsement of a colonial era artifact, but by the framework the Geneva Agreement established. A framework of negotiation, of mutual satisfaction, and of solutions that two sovereign equals can accept. Mr. President, members of the court, I come to my conclusion. On Friday, Guyana's counsel opened their rebuttal by referring to the myths that allegedly power Venezuela's position. There is no merit to that position. But Guyana is right that a myth informs this controversy, a myth enacted by Guyana itself. Guyana casts itself as poor Sisyphus, burdened, toiling, condemned. But unlike Sisyphus, Guyana was not condemned by the gods. It shows its boulder, its summit, and above all, its climb. The boulder is the 1899 award, and Guyana tries to roll it up the mountain of the Geneva Agreement, hoping somehow to reach the summit of a mutually satisfactory solution. But each time the boulder rolls back down, it must roll back down because a corrupt award, but to supersede it. And as long as the agreement governs this controversy, the path forward cannot be the judicial resurrection of a colonial artifact. It must be the practical settlement the parties committed to seek, a mutually satisfactory solution, a summit that once the boulder is set down, Guyana and Venezuela may walk toward side by side. Mr. President, members of the court, I thank you for your kind attention and would ask you to give the floor to Dr. Ariani Cerro Noguera, Attorney General of Venezuela. Thank you.
I thank Professor Menge. I now give the floor to the
Venezuela remains firm in its refusal to recognize the court's jurisdiction. Therefore, its presence here does not constitute, nor should ever be interpreted as and allow Guyana to use this great hall of justice to deny the terms, object, and purpose of the 1966 agreement. In my capacity as Solicitor General of Venezuela and as an international jurist, I will present the final legal observations on this matter. During the course of these oral hearings, you've heard Venezuela's historical truth, which demonstrates its position and its deep commitment to international law as the foundation of peaceful relations among all states. And it is precisely for these reasons that Venezuela has consistently and unequivocally maintained its position that the 1899 award is null and void. This was the reason why, during the decolonization period, Venezuela and the United Kingdom, once the evidence had come to light, put the issue of the 1899 award behind them and redefined their relationship in the 1966 Geneva Agreement. I applaud the statement by the Attorney General of Guyana regarding his country's deep commitment to international law. But I am compelled to recall that the Geneva Agreement is not merely a norm of international law, but rather the norm of international law that Venezuela and Guyana imposed upon themselves. Pacta sunt servanda. Mr. President, members of the Court, I would like to refer to the 1966 Geneva Agreement as the sole binding instrument governing the territorial dispute over Guyana Essequibo. As presented by Professors Mbengue and Zimmerman, Venezuela's position on the real issue or the subject matter of the dispute between Venezuela and Guyana is not the invalidity of the 1899 arbitral award. The real issue of the dispute is the obligation of the 1966 Geneva Agreement to seek a mutually satisfactory solution to the territorial dispute. Regrettably, Guyana has attempted to distort the subject matter of the dispute with the malicious absurdity of convincing the court to legitimize the 1899 award, a product of the unfortunate colonial past that our two countries endured in different ways. Affirming the validity or invalidity of the 1899 award would perpetuate a profoundly illicit and unlawful colonial outcome, which the parties to the Geneva Agreement superseded and set aside. This is a settled and resolved matter. In contrast, the 1966 Geneva Agreement novated the previous legal regime that the colonial power had imposed through structural coercion. By signing the Geneva Agreement, the parties replaced the fraudulent legal framework which had been sought to establish, or had been sought to be established by the 1897 treaty, the 1819 for the practical resolution of the territorial dispute. The Geneva Agreement is part of the decolonization process. This process involves more than merely granting independence to occupied territories. It also entails redressing the injustices of territorial dispossession committed against sovereign states. Mr. President, members of the Court, I will now address Guyana's false allegation regarding Venezuela's alleged acquiescence and its purported theory of cure based on Venezuela's conduct following the issuance of the award. Professors Tuvna and Azaria have demonstrated that this argument is fundamentally flawed and lacks evidentiary basis. On the one hand, there is no legal principle in international law that allows the nullity of an arbitral award to be cured by the conduct of the parties. One cannot remedy what arose from illegality and fraud. In any case, Venezuela has always opposed such a principle, especially during the Vienna Conference on the Law of Treaties. The evidence gathered by Venezuela demonstrates that it never waived its right to invoke the invalidity of the award. This was unequivocally established in the Geneva Agreement. Furthermore, a state may only invoke the invalidity of the award when it possesses evidence to prove it. Venezuela only obtained such evidence following the publication of the Malay Provost Memorandum. Around that time, the British archives were partially opened and subsequent investigations were conducted, which enabled Venezuela to demonstrate the defects in the award. In this regard, Venezuela's conduct reflects the degree of seriousness and diligence expected of a state under international law with respect to challenging an arbitral award of the importance and magnitude of the fraudulent 1899 award. Moreover, the circumstances of the time confirm that Venezuela was a victim of the United Kingdom's imperialist greed. I'm compelled to point out, Mr. President, members of the court, that Guyana maliciously seeks to deny the asymmetry of power that existed between Venezuela and the powers of the time. A country devastated by war was not in a position to confront the world's greatest naval and military power of that area in order to preserve its right to invalidate an award. The absurdity of Guyana's claim does not end there. Guyana asks the court to consider an even more irrational proposition as reasonable. Guyana argues that Venezuela, regardless of the circumstances of extreme military disparities in the early 20th century, was in a position to and was expected to challenge an arbitral award, even without evidence to demonstrate the award's invalidity. And it was expected to do so knowing that it would have to be prepared to endure another war at the hands of its aggressor, a war that it would undoubtedly lose again. With the utmost respect, Mr. President, members of the court, Guyana's claim runs counter to justice, good faith, and defies all reason. Venezuela has made it clear that the real issue and what really matters in this dispute is the 1966 Geneva Agreement. However, Mr. President, members of the court, I would like to raise a third point before presenting my final conclusions. As Professors Tams and Palchetti clearly explained, even if quod non, the dispute concerned the 1899 award, Guyana's assertion that the award is valid completely fails. Venezuela has clearly demonstrated, with reliable evidence, that the 1899 award is null and void, and that Guyana's unilateral submission to the court lacks any basis. First, Venezuela has demonstrated that the 1897 Treaty of Washington is invalid on grounds of error and fraud. Therefore, the 1899 award, which was based on this invalid treaty, is inevitably and consequently also invalid. Second, Venezuela has provided evidence, including contemporary evidence, showing that it was coerced into accepting the 1897 Treaty of Washington. which invalidates the treaty itself, as well as the subsequent 1899 award. There is also contemporary evidence demonstrating that Venezuela was the victim of coercion and during, having been threatened with the use of force in the months immediately preceding the negotiations of the 1897 Treaty of Washington between Great Britain and the United States. Third, Venezuela's historical position has been that the 1899 award also suffered from multiple defects. Venezuela convincingly demonstrated, with substantial evidence, that the award is invalid primarily for two reasons. First, the tribunal did not state the grounds on which the decision was based. Second, the tribunal exceeded its authority. There are 5 instances of this abuse of power. Firstly, the tribunal failed to answer one of the questions posed to it in Article 3 of the Washington Treaty. Secondly, the tribunal failed to apply the rules specified in Article 4. Thirdly, the tribunal acted in a manner inconsistent with the scope of its powers by deciding on matters outside its jurisdiction. Fourthly, the tribunal did not act impartially as required under Article 5. Fifthly, the tribunal failed to fulfill its duty to render a decision based on the law. Mr. President, members of the court, I have 2 concluding remarks. First, I will comment on the documentary record. Despite the obstacles and difficulties created by the United Kingdom to prevent Venezuela from accessing the original sources, we have been able to compile and present hundreds of documents. This documentary evidence has been compiled and analyzed over This process has been a source of deep sadness, as it has laid bare in great detail and reignited the injustice that our country has had to endure for more than 120 years due to the unjust and invalid Treaty of Washington of 1897 and the unjust and invalid arbitral award of 1899, both products of the colonial era that our country had hoped and strived to leave behind. Venezuela is also aware of the probable existence of other relevant documents. With regard to such documentation, the conduct of the United Kingdom and Guyana is inexcusable. Archival documents from April 1970, to which access has only recently been granted, confirm that the United Kingdom actively cooperated with Guyana in the preparation of this case. The relevant file, held at the British National Archives under reference number FCO 63/477, contains documents demonstrating cooperation between the government of the United Kingdom and Guyana's legal advisors regarding the territorial dispute with Venezuela. These documents reveal that British authorities acknowledged they were in possession of archival material that might not be available elsewhere. Consequently, the United Kingdom provided Guyana's legal advisors with access to restricted documents, including confidential material, while denying Venezuela equivalent access. This constitutes a serious violation of the principle of equality of arms. But there's more. The United Kingdom's history of selectively destroying archives in the context of the decolonization process is also confirmed by the documents identified by reference numbers FCO 141 FCO-19928 and FCO-63-476. This must not be ignored. In an effort to remedy this asymmetry, on April 25, 2023, Venezuela transmitted a note verbal expressing its concern regarding Guyana's exclusive access to documents related to the dispute. In that note, Venezuela recalled the existence of a set of documents communicated by the United Kingdom to Guyana without notification or transmission to Venezuela or the United Nations, as required by the Geneva Agreement. Venezuela made a specific request that Guyana share a detailed list of the documents received, as well as any other documents obtained exclusively and without Venezuela's knowledge. Guyana's response of June the 22nd, 2023, categorically rejected any obligation to provide such documentation. I now turn to my second observation. Throughout these hearings, Guyana's lawyers have portrayed Venezuela's position as a myth or a fiction. They also attempted to counter the weight of Venezuela's arguments and historical position with shameful personal attacks and disparagements against Venezuela's legal team. I will not go to Guyana's tactics, which are inelegant, inappropriate, and lack the dignity expected of this type of proceeding, especially from a state that claims to respect international law. These tactics reveal that Venezuela's official position, its arguments, and the evidence supporting them can only be met by Guyana with insults, offenses. Any reasonable observer would see through these tactics and draw the appropriate conclusions from them. Venezuela is very proud of its legal team and is enormously grateful to them for their dedication and professionalism. Mr. President, members of the court, it was the existence of two contradictory positions regarding the validity of the 1899 award that led, in 1966, to the Geneva Agreement. The agreement was not concluded because one party was right and the other was living in a fantasy. It was concluded because both parties recognized that their disagreement could not be resolved by determining who was right about the past, but only by agreeing on a way forward. Venezuela is willing to resolve the dispute over the territorial border with Guyana, but such a solution must be achieved in accordance with the only valid legal framework governing the dispute, the 1966 Geneva Agreement, and its mandate to reach a mutually satisfactory solution. Mr. President, members of the court, this concludes my statement. I thank you very much for your kind attention, and I respectfully request that you grant the floor to the President of the Bolivarian Republic of Venezuela to take the stand.
The Attorney General, I now invite the Acting President of Venezuela, Her Excellency Ms. Delcy Rodriguez, to address the court. Your Excellency, you have the floor.
Mr. President, distinguished members of the court, all those present at this hearing, I come before this court to bring you the voice of a people who deeply cherish justice, peace, and international law. The people of the Bolivarian Republic of Venezuela. On the 3rd of December, 2023, our people turned out in large numbers at the polls and gave us a series of clear and unequivocal mandates. allow me to highlight the following. Firstly, the mandate to maintain the historical position of not submitting existential matters such as independence and territorial integrity to judicial mechanisms. Secondly, the mandate to uphold the Geneva Agreement as the only valid legal instrument for resolving the territorial dispute over Guyana Essequibo. Thirdly, to defend by all peaceful means, in line with international law, the territory of Guyana Essequibo. True to these mandates, I stand before you this afternoon. Mr. President, members of the court, Venezuela's historical position of not submitting matters related to its vital interests to judicial dispute resolution mechanisms is not an act of defiance nor of disregard of the court as an institution. Venezuela is a fervent promoter and defender of international law. For this reason, it respects the International Court of Justice as the main judicial body of the United Nations. However, this is a matter of defending one of the essential attributes of our state, namely its sovereignty. Venezuela has never consented to submitting the territorial controversy over Guyana Essequibo to the jurisdiction of this court. In no way does Article 4 of the Geneva Agreement constitute a compromissory clause. With this in mind, since 2018, Venezuela has filed a number of submissions and has intervened in several hearings before this court with a double purpose. Firstly, to attempt to uphold international law in the face of this anti-legal absurdity promoted by Guyana. Secondly, to demonstrate to the world the truth regarding the rights that since its inception have belonged to Venezuela with regard to the territory of Guyana Essequibo. This does not imply in any way recognition of the court's jurisdiction in the territorial controversy. So, Mr. President, members of the court, the territorial controversy over Guyana Essequibo is governed by a legally binding international treaty that must be complied with by the parties in good faith. This instrument is none other than the 1966 Geneva Agreement. It is a unique treaty for which it would be hard to find a parallel in decolonization practice. It seeks to resolve a colonial injustice through a mutually acceptable settlement. A negotiated solution is, therefore, an inevitable and an indispensable condition of the controversy. The Geneva Agreement buries and moves beyond the discussion over the validity or the invalidity of the 1899 award. The agreement recognizes that the framework cannot be circumvented, reformulated, nor replaced through unilateral recourse to judicial resolution. It is law between the parties. The preparatory work on the Geneva Agreement, its title, its preamble, its articles, as well as the subsequent practice of the parties, demonstrate that resolving the legal issue of the validity or invalidity of the award was never on the horizon. It was not ever a legal controversy. The object, the nature and the purpose have always been to resolve the territorial controversy over Guyana Essequibo through political, peaceful and diplomatic negotiation. The dispute, the controversy does not concern the confirmation nor the invalidation of an award. They specifically agree upon a method of resolution. For that method is negotiation, not imposition. No winners or losers. This negotiation process was neither exhausted nor was it abandoned by Venezuela. It was undermined by Guyana's conduct at a time when the mechanisms provided for in the Geneva Agreement remained fully in force. Guyana unilaterally chose to shift the controversy from the realm of negotiation to that of judicial resolution in open violation of the agreed upon legal framework. That shift was not innocent. It coincided with an oil find in 2015 described as world-renowned. Guyana, at that point, ceased to act in good faith and harbored a silent intention to evade compliance with the Geneva Agreement. From that moment on, Guyana abandoned the logic of a mutually acceptable solution, and it adopted an unlawful strategy of judicialization aimed at obtaining through this court and without Venezuela's consent what it was not able to achieve under the Geneva Agreement, i.e. validation of a fraudulent award. It was an all or nothing approach. Negotiation was replaced by litigation, good offices by pressure, and political consensus by a unilateral action that perpetuates and exacerbates the dispute. Venezuela cannot accept this shift, driven by Guyana redefining the nature of the controversy or the manner in which it should be resolved, nor can it support the use of the court as an instrument to consolidate that change in violation of the Geneva Agreement and of international law. Mr. President, this is not a criticism of the judicial function. On the contrary, it is a defense of its scope. This court was not created to supplant the will of states, but to act within the limits defined by that will. And those limits, in this case, are clearly established in the Geneva Agreement. Let's be clear, Venezuela will not renounce its history nor its legitimate rights, rights expressly recognized and preserved in the Geneva Agreement, simply because Guyana now seeks unilaterally and opportunistically to redefine the controversy. For us, the Guyana Essequibo is not just about mere economic and commercial interests. It is part of our inalienable historical legacy. Guyana is evading its obligations. It's seeking to revive a debate over the validity or the invalidity of the award. And through this manipulation, the agreement itself, the Port of Spain Protocol, and decades of bilateral negotiations, including those conducted under the good offices of several UN Secretaries General, are being disregarded. And this is not an oversight. It is a clear violation of the 1966 agreement, which does not stand up to rigorous scrutiny. The narrative presented belongs to a different account, one that is divorced from historical and legal precedent. It invites the court in bad faith to set aside more than a century of state practice in favor of a doctored version of reality. Mr. President, members of the court, as part of its defense of the truth, Venezuela has made available to this court and henceforth to the world abundant evidence confirming its historical rights over Guyana Essequibo, as well as the parties' decision to resolve the territorial dispute through the Geneva Agreement. Despite the British blockade of evidentiary sources, and despite the destruction of documents, Venezuela has compiled and submitted a comprehensive and coherent body of documentation consisting of more than 3,000 pages of evidence distributed across a number of volumes. The body of evidence presented to the court includes international treaties and agreements. It includes colonial and historical documents, extensive diplomatic correspondence, negotiation records, official statements, United Nations documents, as well as a substantial collection of maps. Taken as a whole, this evidence confirms the nullity of the 1899 arbitral award. It also unequivocally reflects long-standing practice and mutual recognition by Guyana and Venezuela of the existence of a territorial dispute and the need to resolve it through direct negotiations aimed at reaching a mutually satisfactory solution as established in and required by the 1966 Geneva Agreement. The evidence is irrefutable. Guyana Essequibo has been part of Venezuela's territory since the country's inception. In 1777, the Spanish crown created the Captaincy General of Venezuela, comprising, among others, the province of Guyana. This administrative unit is the territorial origin of what later became the Republic of Venezuela, which arose from its Declaration of Independence, its 1811 Constitution. Since then, every constitution of the Republic of Venezuela has reflected the fact that Guyana Essequibo is part of Venezuela's territory. In 1825, the United Kingdom recognized Gran Colombia. Its eastern border was the territory of Venezuela's Guyana Essequibo. The United Kingdom never held any title to the territory of Guyana Essequibo. Its successor state did not hold it either, and does it hold it now, though it seeks to artificially forge such a title through this misleading proceedings. Beginning in 1840, the British Crown, aware then of the immense gold reserves in the territory, designed a strategy to plunder it. To this end, it enlisted a German adventurer to unilaterally draw an arbitrary line within Venezuelan territory, the so-called Schomburg Line, which has never been validated nor recognized by Venezuela. Later, the United Kingdom attempted to consolidate this dispossession through a sham arbitration, which concluded with the fraudulent and rigged award of 1899. Today, there's an attempt to validate that fraud through this biased process riddled with legal inconsistencies. There are even those who have dared to publicly predict the outcome of these proceedings. The truth of the award and its deceptive nature highlight Guyana's intention and that of those who pushed it towards this reckless action, to tarnish and to erode the prestige of this court. How can they expect this court to stain its own history with a ruling that revives, validates, legitimizes such a case of colonial judicial fraud? Mr. President, distinguished members of the court, the negotiating process carried out by the parties following the signing of the Geneva Agreement demonstrates that there are various mechanisms available to definitively resolve the territorial dispute. All are based on political dialogue and direct negotiation between the parties. Both in the Joint Commission talks and in the Good Offices process, both parties forward creative proposals aimed at reaching a practical, satisfactory, and mutually acceptable settlement. In fact, the former Prime Minister of Guyana himself, Forbes Burnham, signatory to the Geneva Agreement, proposed signing a new agreement that would settle the border issue linked to the construction of a hydroelectric project in the Upper Mazaruni region. It should be noted that every step, every mechanism throughout this whole process was adopted with the prior and express consent of both parties to the Geneva Agreement. Regrettably, the UN Secretary General abandoned this practice, this repeated practice, which had been followed for over 50 years, yielding to strong and intense pressure from lobbyists hired by the Cooperative Republic of Guyana, driven by powerful energy interests, as we can see from the confessions of the former Guyanese minister, Raphael Trotman. This led to a dangerous exacerbation of the controversy between the parties. President, distinguished members of the court, the global energy landscape points to high demand for hydrocarbons in the short and in the medium term, driven, amongst other factors, by a boom in new technology. As you know, Venezuela has the world's largest reserves of oil on the planet, and it's considered a strategic target by major powers. At the heart of the current development of this territorial dispute lies the region's hydrocarbon wealth, which has sparked the interest of major consumers and transnational oil companies that see the resources available in the area as a major opportunity. These vital interests have further complicated this historical dispute. We have no doubt that only a practical, satisfactory and mutually acceptable settlement can create the conditions of stability and trust required for both countries, as well as the interests of third parties present, to fully capitalize on the potential of this territory for the benefit of sustainable economic development and for the social well-being of the peoples of the region. Mr. President, the dichotomous approach of validity or invalidity of the award put forward by Guyana in its unilateral application is profoundly pernicious and futile. No judgment by this court on the territorial controversy will provide a definitive solution acceptable to both parties. On the contrary, it will exacerbate the differences between the parties and will lead the parties to entrench themselves in their respective positions, distancing them from the practical, satisfactory and mutually acceptable settlement to which they committed in 1966 by signing the Geneva Agreement. Such a judgment may conclude the case, but it will not put an end to the territorial dispute over the Guyana Essequibo as conceived and as agreed upon by Venezuela, the United Kingdom and Guyana. At best, it would lead to a return to the same impasse that the Geneva Agreement overcame. Proof of this can be found in Guyana's unprecedented and extravagant submissions before this court, which reflect an inexcusable spirit of superiority. Just as colonial empires erased the history of the peoples they sought to dominate, this court is being asked to order the destruction of maps, to prohibit the teaching of history, to eliminate symbols, to tear Guyana Essequibo from the hearts of Venezuelans. The aim is to erase the memory of a people in order to nullify their future. Annihilating history will never, never legitimize dispossession. The truth will always prevail. Mr. President, this court was created to resolve conflict, not to encourage conflict. Only a political and negotiated solution to the territorial dispute can lay a solid and stable foundation for good neighborliness, cooperation, shared economic development, and the promotion of secure investment in the region. Venezuela will never endorse a violation of the Geneva Agreement and international law to validate a ruling that seeks to disregard a legal instrument that is in force and that has been duly deposited with the United Nations would run counter to the international legal order. Even if the court were to declare the award invalid, Venezuela would be unable to comply with such a ruling, as it would also be nullifying the Geneva Agreement and international law. It follows very clearly from this that there is no legal way of recognizing a decision resulting from this process, whatever that may be. President, members of the court, this is not an act of disrespect towards this esteemed court. It is an act of unwavering defense of Venezuela's rights, of international law, and of the integrity of this court as the main judicial organ of the United Nations. My presence before this court demonstrates not only the importance that the territory of Guyana Essequibo holds for us as Venezuelans, it is also clear evidence of the respect we have for the court as an institution. Mr. President, Venezuela is ready and prepared to achieve the noble and peaceful purpose of the Geneva Agreement, to reach, by all means at its disposal, a practical, satisfactory, and mutually acceptable solution for the parties. In today's turbulent world, we have reached a historic moment where we can demonstrate that dialogue and negotiation are the path towards coexistence, happiness, and well-being for our peoples. It is time to take a step forward. There's no other way. A high-level bilateral meeting organized by key regional stakeholders will, without doubt, be far more productive and effective in achieving that goal. Mr. President, members of the court, a country's virtue is not measured by its territorial size, but by its efforts to legitimately defend its sovereignty, its territorial integrity, and its inalienable rights. Guyana and Venezuela are called upon by history and by geography to coexist, to understand one another, and to build a shared future. Therefore, the only real path forward for this controversy is a return to direct dialogue and the search for creative and mutually beneficial solutions that will allow us to turn a dispute inherited from colonialism into an opportunity for cooperation, joint development, and the well-being of future generations of both peoples. Contrary to what has been said, Venezuela has always fully supported the decolonization of Guyana, and it recognized from the beginning the Cooperative Republic of Guyana, while still defending its rights over Guyana Essequibo. Venezuela also promoted its development through development programs such as that of Petrocaribe. Unfortunately, Venezuela is still victim of territorial colonialist dispossession, and it is not receiving repairs for that. The people of Guyana, I say Venezuela is a peaceful nation, and our common destiny will always, always be intertwined. Venezuela, however, will never surrender its historical rights and its territorial integrity, the legacy of our ancestors. 127 years later, we stand up, despite serious aggressions and threats, to defend the territory of Guyana Essequibo. We bear on our skin the scars of history, and in our souls, the tenacity of peoples who learn to do what is ours, to not give up in the face of difficulty, and to march together towards a future of peace and development. Thank you very much, distinguished President and members of the court. I'd now request that our agent, Samuel Moncada, be given the floor.
The acting President of Venezuela for her statement. I now call the agent of Venezuela, His Excellency, Mr. Samuel Moncada, to the podium. You have the floor, sir.
Mr. President, members of the court, I will now read for the record the closing statements of the Bolivarian Republic of Venezuela in these oral proceedings. In the case concerning the arbitral award of 3rd of October 1899, Guyana versus Venezuela, for the reasons explained in the written oral phases, the Bolivarian Republic of Venezuela respectfully reiterates its request to the court to 1. Abstain from intervening in the territorial controversy between Venezuela and Guyana on Guyana Essequibo, and from interfering with the obligations arising from the 1966 Geneva Agreement regarding the settlement of said dispute in an amicable, satisfactory, and acceptable manner for the parties by means of peaceful, political, and diplomatic negotiations. And secondly, consequently, to refuse to hear and dismiss the Cooperative Republic of Guyana's claims. Finally, on behalf of the Venezuelan team, I would like to thank you, Mr. President, members of the court, the registry, and its staff. We also extend our sincere gratitude to the interpreters for their excellent work, and in particular for the interpretation of these oral pleadings into Spanish. My thanks go as well to the delegation of Guyana. In addition, I would like to express my deepest gratitude to Venezuela's distinguished council and to the women and men who make up the Venezuelan delegation. It has been both a privilege and an honor to work alongside you in this case. Thank you very much for your kind attention.
I thank the agent of Venezuela. The court has taken note of the final submissions of the parties. I'd like to thank the agents, counsel, and advocates for their statements. In accordance with practice, I shall request both agents to remain at the court's disposal to provide any additional information it may require. With this proviso, I declare closed the oral proceedings on the merits in the case concerning arbitral award of the 3rd of October 1899, Guyana versus Venezuela. The court will now retire for deliberation. The agent of the parties will be advised in due course of the date on which the court will deliver its judgment. Since the court has no other business before it today, the sitting is closed.
you.